I was in a big box store. It was a year ago in August, and I slipped in some water. The roof was actually leaking. And I pulled the piriformis muscle that's in my back.
Okay.
Now, I went to the doctor. My personal insurance paid for my doctor visit, but they have not paid any for the physical therapy that I received, which was about, 6 or 7 months of physical therapy, which, took my time. It took my mileage, driving there. And, going to physical therapy 3 times a week, eats up a lot of time.
Sure.
But so far, like I said, it was a year ago in August, and so far I'm getting the runaround from this big box company's insurance. And first of all, I was wondering if there was some kind of statute of limitations on how long they had to pay.
Right.
Because that's my first concern.
Right.
Sure. Okay. Well, Wendy, we hate to hear that that's happened to you and you're dealing with that. But Seb, what kind of information would you help her with?
Well, there's a 2-year statute of limitations in Alabama to file a claim like that. And my advice to you would be not to wait until the statute is about to run to, go ahead and seek advice from somebody who can give that to you. It sounds like you slipped in some water that was caused because the roof was leaking. That is a situation where there's probably going to be liability on the part of the premises owner. I've handled premises liability cases all of my career. They can be difficult, but in that situation where the roof had not been repaired and that caused the water to be there, that's going to be a situation that you can prove that the premises owner was negligent for not repairing the roof and thereby it caused the water to collect on the floor. Sometimes you run into problems when you've got water on the floor in a store where, for example, another customer who's in the store spilled the water. In that situation, that's not the fault of the premises owner, of the store owner, but if the store owner allows it to be there a sufficient time, then they can be responsible for that even though they didn't cause it. Premises owners have a duty to inspect their premises to discover hidden defects, and if they don't do that, they can be liable for your injuries. But in your particular case, their negligence was for not repairing the roof.
Yeah. Well, Zeb and Kirby, I think it's important for Wendy to know, too, that if she does talk to someone like yourself, who's a personal injury attorney, contingency fees is a huge thing that she needs to be aware of.
Yeah, a couple of things I heard there that I would mention to Wendy. One is, Wendy, I would get to see a lawyer fairly soon because sometimes the business is not the property owner, and we have to figure out who the property owner is in addition to the business, so that can take a little bit of time. And also, when you see a personal injury lawyer, number one, you do not have to pay for a consultation with most personal injury lawyers that I know. And second, personal injury attorneys like us work on a contingency fee, which means you'll never owe us anything. We only take a percentage of what we recover for you, and that allows us to litigate against big companies like the one you're describing.